Today on Don't Talk TV, I want to talk about one of the most important and absolutely foundational aspects of criminal justice in Canada, and that is the presumption of innocence and the burden on the prosecution to prove a case beyond a reasonable doubt. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Over the past month in the United States, there was a very high-profile case, that of Minnesota versus Derek Chauvin. As many viewers of Don't Talk TV are no doubt aware, Mr. Chauvin is an ex-Minneapolis police officer who was recently convicted of the murder of George Floyd, an African-American man who died while being arrested by Mr. Chauvin, and I'm sure many of you have seen the infamous clip where Mr. Chauvin was kneeling for over 9 minutes on Mr. Floyd's neck. I watched a fair bit of that trial. It was very interesting, and it was broadcast live over the internet. But one thing that really struck me after the verdict was delivered were some of the opinions put forward by American media. Now, I certainly recognize that this channel is directed towards a Canadian audience, but I also know that many Canadians watch American media. And I think it's also safe to say that a lot of attitudes in the United States have a tendency to find their way up into Canada because of the close bonds that our countries enjoy. So what particularly drew my attention was a series of tweets from legal analysts with a variety of mainstream media networks. The first of these was from the senior legal analyst at CNN, Laura Coates, who I understand is a former Department of Justice lawyer. She criticized Eric Nelson, the defense attorney for Mr. Chauvin, in his closing submissions by saying, quote, "Defense begins the closing by defining reasonable doubt, not with why Derek Chauvin is innocent. Think about that," end of quote. Mr. Nelson's just doing his job as a criminal defense lawyer, but let me continue. The next one I have here is from MSNBC legal analyst Glenn Kirchner, and what he says, when you have no compelling facts/evidence supporting your defense, you start with a long-winded discussion of legal principles like presumption of innocence and proof beyond a reasonable doubt. That's how defense attorney Nelson started his closing argument. This is a tell, suggesting that because a lawyer is relying on this foundational principle of criminal law, that his client must be guilty. And finally, NBC News legal analyst Barb McQuaid weighed in as well, saying, quote, "I have found that the defense spends more time on presumption of evidence," I think she means innocence, "and reasonable doubt when he does not want to focus on the facts of his own case." So these are all clear attacks on the presumption of innocence and the burden on the prosecution to prove a case beyond a reasonable doubt. It's suggesting that an individual, if they're innocent, they're going to have evidence. They should be showing evidence why they're innocent, and that if the lawyer is relying on this, that they're guilty. It's essentially turning reliance on the presumption of innocence into a presumption of guilt. This is extremely, extremely dangerous, and I want to look at the history and the principles of this presumption of innocence, and this will demonstrate, I think, very clearly why it's so dangerous to be having these sorts of conversations. Just simply stated, to begin with, what is a presumption of innocence? Well, it's a presumption or an assumption that the person is innocent. So when an accused person enters a court, they start with a clean slate, assumed to be innocent. And then the accuser, being the state, has to move aside or destroy that presumption of innocence beyond a reasonable doubt to the point that you can now find that person guilty because a jury or a trier of fact can say there's been so much evidence presented that that's moved away, that's pushed aside that presumption of innocence, and I'm now satisfied beyond a reasonable doubt. Now, a reasonable doubt that's not a frivolous doubt or just any doubt, it's a reasonable one, but beyond a reasonable doubt is what's required to find someone guilty. Now, this is something that goes back very far in human history and in our laws. It can be traced all the way back to the Roman Empire and the code or digest of laws compiled by the Emperor Justinian. And he provided as a general rule that under Roman law in the 6th century, that proof lies on him who asserts, not on he who denies. In the Middle Ages, these Roman principles continued to be applied, and it's carried on through to our day, as we've inherited our common law from the United Kingdom. The right to presumption of innocence is guaranteed by Section 7 of the Charter of Rights and Freedoms, which once again reads that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. And the right to be presumed innocent until proven guilty beyond a reasonable doubt is a principle of fundamental justice. It's also something guaranteed by the United Nations in their Declaration of Human Rights, Article 11. Now I want to take a look at one of the leading cases on reasonable doubt in Canada, that being Her Majesty the Queen in Lifchus, a 1997 decision of the Supreme Court of Canada. If we go down to paragraph 13, the court described the fundamental importance of understanding the onus resting upon the Crown. And they said, quote, "The onus resting upon the Crown to prove the guilt of the accused beyond a reasonable doubt is inextricably linked to the presumption of innocence. That jurors clearly understand the meaning of the term is of fundamental importance to our criminal justice system. It is one of the principal safeguards which seeks to ensure that no innocent person is convicted. The Marshall, Morin, and Milgard cases serve as a constant reminder that our system, with all of its protections for the accused, can still make tragic errors. A fair trial must be the goal of criminal justice. There cannot be a fair trial if jurors do not clearly understand the basic and fundamentally important concept of the standard of proof that the Crown must meet in order to obtain a conviction." The Supreme Court sums it up excellently right there. I mean, presumption of innocence and the burden remaining on the accuser, or the Crown, is absolutely essential to a fair trial. And in addition to the cases listed by the Supreme Court in that 1997 case, I started my career as a Crown Attorney in Manitoba. The Sofino inquiry was ongoing at that time. Mr. Sofino was an individual who was convicted of a horrible rape and murder and was only acquitted years and years later after spending long years in jail because of new DNA technology that exonerated him. And this concept that we should not be convicting innocent people is something that's been long cherished in our history. Again, it goes back to our British legal heritage and the often reported phrase from Lord Blackstone in his work Commentaries on the Laws of England, published in the 1760s, that said, "It is better that 10 guilty persons escape than one innocent suffer." And that's one of the key principles that our law is based upon. And I think it's very important to not lose sight of the fact that these laws are really here for your protection, the general public's protection. Some people will think, well, it's worth getting rid of these laws, or it's worth getting rid of the presumption of innocence to get someone as awful as Derek Chauvin, who was caught red-handed. It was videotaped on camera, all 9+ minutes of it. Why should we have a presumption of innocence for him? We need to have a presumption of innocence for him, and for the Paul Bernardos, and for the Ted Bundys of the world, so that that presumption of innocence will still be around if you're ever required to appear in court. Many people think, well, that will never happen to me, but it can happen to you. Malicious accusations can happen, misunderstandings, evidence that misleads police can happen, and again, I've already referenced certain wrongful convictions. Those were literally wrong person in the wrong place at the wrong time type of cases where people were convicted. So it can happen. And I guarantee that all those legal analysts who I referenced who were mocking Eric Nelson, the defense attorney for Derek Chauvin, if any of them were ever charged with a criminal offense, I guarantee that they would want that protection of the presumption of innocence as well. And I would also suggest this, that if you ever lose a right, like that to be presumed innocent until proven guilty beyond a reasonable doubt, you will never get that right back. And therefore it needs to be jealously guarded. And that's why I felt it was so important to make a video on this topic today. This video isn't legal advice itself. If you have a situation that you're in where you need legal advice, you can contact a lawyer. Call another lawyer or call myself. My 1-855 number is below. If there's any topics that you'd like to see me cover, please leave a comment in the comments section below. And if you found this video helpful or informative, please consider liking, sharing, and subscribing.